standing right behind me. So we've got 3 good papers today on the topic of American state courts. We've got research by Mike Fix, Todd Curry, and Mike Romano looking at the interconnectedness of state high court Twitter. We've got Marcy Shieh, who will be looking at the effect of news and contributions on the public interest of state Supreme Court candidates. We've got Teena, Wilhelm, and Rich Vining looking at diversity among the Chief Justices, professional experiences, and personal characteristics from a forthcoming book of theirs. And we're really, really fortunate to have Melinda Gann Hall with us to discuss these papers. And so just to get the ball rolling, I will hopefully go in the order that the papers were presented on the flyer. So we can start with Mike, Todd, and Mike looking at the interconnectedness of state high court Twitter. And I will turn it over to you folks.
Okay, is my screen share working? Okay, fantastic. So essentially, Todd and I had a paper a couple of years ago that some of you may have seen that was sort of a first cut at looking at Twitter use by state high court judges. There's lots of research out there looking at more traditional politicians and their Twitter use, but nobody had really looked at judges before. So then after we did that initial take, which was really just kind of a first cut at it, Mike Romano came on board with us, and building off some work that Todd and Mike did in their recent book, we started looking at how not just individual judges are using Twitter, but also sort of trying to look at the relationship between different judges on Twitter and how that connects to other things. And so the thing about judges on Twitter is that a lot of the things that they tweet are just sort of the same sort of ordinary everyday things that we would tweet. I mean, just, looking at a couple of judges in the last week, Judge Dillard of the Georgia Court of Appeals, who is our most prolific tweeting judge in the country, is tweeting about Samford football, his alma mater. Chief Justice Bridget Mary McCormack of the Michigan Supreme Court is making a joke about Taylor Swift's scarf. So we're seeing judges that are tweeting about the same sort of stuff that we tweet about, that just regular Twitter users tweet about. So a fundamental question that we ask in sort of this line of research is, why are judges doing this, right? What's in it for them? Why are they using Twitter? And so essentially one thing that we sort of combine here again is research on judges and their audiences, which builds from Larry Baum's work, and then the stuff that Mike and Todd have done looking specifically at state court judges and their audiences, and looking at how judges have to be concerned with multiple audiences at the same time when they're engaged in any sort of public activity, and obviously social media use fits in this category of public activity. Todd and I then had done some early work looking at judges and Twitter, and we argued in that first paper that there were really 2 benefits that we saw primarily for state court judges to use Twitter. One of these is a sort of benefit to the whole court, right? When judges use Twitter and they use it in an appropriate way, they can increase knowledge of their court. And we know from previous literature that increased knowledge of courts tends to increase the legitimacy of the court. And so while this isn't an individualized benefit for the judge using Twitter, it can be a benefit for the court as a whole, as a collective, when more judges are on Twitter. Secondly, a more individualized benefit is name recognition, right? Just by being on Twitter, by getting out there, judges can connect to their constituency. Obviously, this is specifically a benefit to judges on elected courts, on courts with competitive elections or even retention elections. Todd and I found. But as we sort of looked at this further, we thought that maybe Todd and I missed something in that initial paper, and sort of combining what Todd and I found in that initial paper with the work that Mike and Todd had done specifically looking at state court judges and how they relate to their audiences, we thought that maybe there's a third reason going on here. And this third reason sort of combines a variety of goals that judges might have, collegiality goals about gaining professional recognition, and also a notion of progressive ambition, right? And so by being on Twitter, judges can increase their sort of prestige among fellow judges, and for those that have progressive ambition goals, among politicians who might have some ability, even in states that don't have elections, to influence the course of their career, or for judges who could have some influence on getting them federal judicial appointments. And while obviously this may not be the main way that they got on the radar, we do know just anecdotally that at least 4 state high court judges who use Twitter in to some degree were appointed to the federal bench during Trump's presidency. So perhaps the visibility that they gained on Twitter did help them get on the radar of the people who helped make the list from which Trump selected his judicial appointments. And so the data we use for this is the data that we borrowed from the earlier work we've done on judges and Twitter. So it's getting a little bit dated. It's probably time to go back and get some more updated data, looking at the few judges who have joined Twitter since we did this initial stuff, and getting more updated data on the judges since the initial cut. But the initial cut of the data was made in summer of 2017, and we collected information on every judge, every state high court judge that was active on Twitter at that point in time. And at that point in time, there were 49 state high court judges active on Twitter. What we're looking at primarily in this project, where we're trying to sort of map out these relationships and connections between state high court judges using Twitter, we're going to focus primarily on degree centrality. I think that Mike Romano is here. He did most of the analysis on this. So if you have any questions about other things that he might have looked at, he did most of the analysis work here, and he can probably answer those during Q&A. But just as a quick glance, there's quite a bit of variation in the number of connections within the judicial Twitter network that we see. There was a handful of judges, I think 2 in our data, who had no connections with any other judges via their Twitter accounts. So they didn't follow or weren't followed by any other judges. On the other extreme, we had judges in our data we had a couple of judges in our data that had a centrality measure greater than 10, who had connections with a lot of the other judges in the Twitter and in the judicial Twitter network. So if you think about that, if there's 49 total judges in this data set, connecting with 10 other judges is more than 20% of the judges in the network. So some of the judges that are most central to the Twitter network are connected with a substantial portion of the other judges out there. These are probably impossible for you to read. We're happy to share a working paper where these pictures are actually readable for anybody who wants to read more about judges and Twitter. But this is just a quick snapshot of the Twitter networks, and what you can see is you've got a few judges that are really out on the periphery. Those are the ones that don't have connections to many other judges. And then the judges that are really central to the network, judges like Chief Justice McCormick of the Michigan Supreme Court are really core to the network. Some of the basic things that we found that were highly predictive of who would have the most sizable connections were not really surprising, and were consistent with the earlier work that we'd done on this. You can see that elections, contested elections, is significant as a predictor of the centrality of each judge. Clearly, those judges, I had the actual figure here, sorry, just slightly disorganized. Trying to work off multiple screens at once. Okay, I can't find the size of the substantive effect, but it was relatively large. It was our largest substantive effect. Being in a state that uses a contested election to retain judges increases the probability of a connection by a little over 14%. So that's the substantive effect of that. And so being in a state with contested elections was the strongest predictor of the connections between judges. Other factors really didn't seem to matter: how long they'd been on the court, the length of terms, whether or not they were a chief justice, or even how long they'd been on Twitter. Some of the sort of usual suspects in the literature for things that tend to explain judicial behavior in other contexts, as well as just something as intuitive for Twitter as how long they'd been on Twitter, really didn't seem to matter. One interesting Twitter specific thing that again wasn't surprising is that while some of these are more general Twitter accounts, others are very campaign specific. So they create an account just for their election or re-election campaign, use it for that campaign season, like a lot of other politicians do, and then just leave it by the wayside, either forever or until their next election. Those accounts, as you can see by the negative coefficient, did not have nearly the number of connections as accounts that were used much more actively. Tentative conclusions. The judicial Twitter network is quite interconnected, but there's also quite a bit of variation in how it's used. Judges who face contested elections are the most likely to be to have more connections. Interesting enough, in this data, there were no judges in a state with a lead appointment as the method of selection, because there were none that were on Twitter. As of mid-2017, there were exactly one judge who had a Twitter account, a public Twitter account, who was from an elite appointment state, and that account had exactly 0 tweets. Since the initial cut of the data, actually, he's become active, and it's Justice John Cannon Few of the South Carolina Supreme Court. And now he's a quite active Twitter user. So he is truly an anomaly. He is the one state court judge selected by elite appointment who uses Twitter actively now. And so we can have some hope that he'll be a model for the federal bench, and we'll see some federal judges tweeting soon. But anyway, that's our preliminary findings. We hope to find more, and I think I might be actually slightly over time, so I'm just going to wrap up there.
All right, thanks, Mike. Up next, we have Marcy Shieh, who's going to discuss a subject near and dear to my heart, which is the effects of news and contributions on public interest of state Supreme Court candidates. Marcy, all yours.
Okay, just unmuted myself. Thank you, David, for organizing this, and thank you, Melinda, for agreeing to serve as discussant. So I'm Marcy Shieh. I'm a PhD candidate at the University of Wisconsin-Madison, and I'm presenting a paper on using contributions in the public interest of state Supreme Court candidates. So my two research questions here are, do different types of news stories influence the public interest of these state Supreme Court candidates? And are the effects of news stories on public interest greater or less than campaign contributions? So you may wonder, why is public interest in courts important? So over the years, state courts have become increasingly relevant in daily lives of Americans. They have a hand in everything from civil rights to workers' compensation. So given this, like, voters can really benefit from learning more about state Supreme Courts, the campaigns, the candidates running in those elections. So the main argument in my paper are different types of news stories can increase or decrease public interest of state Supreme Court candidates, and campaign contributions are better at increasing public interest of state Supreme Court candidates. So better as in more effective. So my expectations include 3 hypotheses that are derived from literature about campaigns and elections in general. So my first hypothesis here is that campaign-related articles increase public interest more than judicial-related articles. So there is a lot of work out there about horse race coverage and how people are drawn to scandals and how these sort of sensationalized stories seem to capture the attention of people who don't normally look at the news. I would assume that campaign-related stories are able to cast a wider net in terms of their audiences because they tend to be fluffier stories. My second hypothesis is that judicial-related articles decrease public interest compared to these campaign-related articles. So this expectation is derived from the idea that a lot of people are avoid legalese. They don't know the average person doesn't know that much about the law. And also when the media reports on the courts, they tend to focus on the court cases in general rather than the individual justices themselves. So the justices themselves don't get much article space. And my third hypothesis is that campaign contributions are more effective at increasing public interest in campaign or judicial related stories. So this expectation is derived from the idea that contributions tend to be influential in more places other than just articles or media coverage. It could lead to ad buys and so on. So my findings in this paper is that campaign-related articles increase public interest and judicial-related ones decrease public interest. That said, campaign contributions are better at increasing public interest in judicial articles. So that confirms one part of hypothesis 3, and campaign contributions are less effective, however, at increasing public interest in campaign-related articles too. So this is sort of contradictory to one part of my third hypothesis. So my data comes from, so the dependent variable that I'm interested in is the Google Trends data from 2004 and 2020. So essentially this data set shows gives you a estimated hit, not a raw count, but like an estimated index of a particular justice's popularity during a certain time period. So for example, if I looked up Wisconsin State Supreme Court Justice who was running for re-election, Daniel Kelly, in 2008. So if I looked at the time frame from January 1st to April 7th, 2018, on election day, he would be getting more hits. So that would be his highest. And compared to a date like March 8th, 2018, he may have very few hits. So his popularity would be somewhere around 0, right? So as you can see, here's some a line graph of my mean estimated hits. So these are the average number of estimated hits per year per these state Supreme Court justices running for re-election. So my independent variables, I look at justices who are running for re-election. That gives me campaign-related articles, so them being on the campaign trail, and judicial-related articles, them deciding cases on the court. In order to determine whether or not a particular article is a campaign-related or judicial-related article, I look at the headlines of these articles. I got these articles from LexisNexis. It was applied to, I looked at about 18,000 different articles. I created dictionaries for campaign-related terms and judicial-related terms. So the campaign-related terms was from this glossary from the US Election Assistance website that has all these terms for people who are interested in voting or learning more about voting. And the judicial-related terms are from the US Courts website and the Department of Justice website. So there's a lot of legal related words in those two dictionaries. I got daily campaign contributions data from some staff researchers at Follow the Money. They were really helpful. And so here's a line graph comparing the campaign and judicial related terms in the headlines per year. As you can see, campaign-related terms are more often used in headlines to sort of catch people's attention, while judicial-related words are not used as often. You see a weird dip in 2005. That could just really be in 2005, only Pennsylvania had re-elections for state Supreme Court. So that might be picking up sort of the scandal part of the Pennsylvania Supreme Court, not so much of the daily judicial business part. So here are examples of article headlines. So the underlined word are words that are in the judicial dictionary, and the words that are bolded are words from the campaign dictionary. The one word that was in both dictionaries was the word file. So as you can see, it's both file and underlined. I just calculate the proportion of how many words are judicial or campaign related over how many words are in the headline. So as for methods, I use a hierarchical linear model. My outcome variable is estimated hits per day from Google Trends. I is the number of observations, so each observation is a news article in this case, and J is the candidate date state that each observation belongs to. B0 is the intercept, B1 is the proportion of campaign-related terms, beta 2 is a proportion of judicial-related terms, and beta 3 is the amount logged campaign contributions on per day. And the final the B and J variable represents other controls. So some of the controls I looked at include publication type, candidate level information, and the state selection methods. And also I have an error term in there. So as the results show, this coefficient plot shows the effects of the proportion of campaign and judicial words and campaign contributions on public interest. Reiterates my main findings. So campaign related terms increase public interest as measured by Google search queries. Judicial words decrease public interest. People search for these justices' names less when there are more judicial news out there. And as for campaign contributions, they are more effective at attracting public interest in judicial words, but less so than campaign words. So in conclusion, our results suggest that campaign-related coverage attract more interest in these judicial candidates than judicial-related coverage. And it seems like the public tends to focus on the campaigning aspect of a justice rather than their judging aspect, what they do for a job, basically. So people sort of shift their attention to what they do on the campaign trail, even though justices and other public officials tend to alter their behavior in re-election years. And hopefully these results suggest how to sort of motivate engagement and participation in low information elections. And in the future, it would be cool to use an experiment to disentangle these relationships and see whether or not a particular type of article actually motivates a subject to search the name or something else in general. So thank you, and I look forward to everyone's feedback.
Thank you, Marcy. Up next, we've got Teena, Wilhelm, and Rich Fining. So I'll turn it over to y'all.
Yeah, we can get the screen sharing going here. Maximize. All right. Hello, everyone. Thanks to David for inviting us to take part today. Thanks to Melinda for the commentary she'll deliver. I really appreciate the opportunity here. We are going to present some research on diversity among Chief Justices, both in terms of professional and personal characteristics. That is a piece of a larger book project that we have been working on for the last year or so, and related work for longer, clearly. I guess I'll give you kind of a broad overview here. The book is going to look broadly at several different things with regard to the state's Chief Justices. We wanted to shine a light on Chief Justices, looking at more than just sort of intra-court coalition building or peer votes to pick a certain chief, something like that. So we chose to focus on the administrative side of Chief Justice leadership in the book. The first part of the book, however, does a lot of laying of foundations and background information about Chief Justices, how they're selected, how long they serve, who occupies the position, and et cetera. So today we're actually doing a piece of that front end of the book, looking at professional backgrounds and personal characteristics of Chief Justices from states. Again, we argue that they deserve a lot more attention than they get broadly, especially in terms of their administrative duties. So we tried to do as much as we could to shine, again, a spotlight on these individuals and what they actually do on the job. And there's lots of anecdotal evidence and commentary that suggests that we really should be looking at this part of their responsibilities. So far, a lot of that work that did so was in public administration literature. A lot of it is from the 70s and 80s. Political scientists haven't taken a really strong look at this in quite some time. So we're trying to, again, look at developments that have happened and how those chiefs play into state politics, again, with selection and diversity and things like that being a part of that bigger picture. Today, the data we're going to be looking at come primarily from Greg Golshauser's data from his 2016 book that we then corrected where there were errors that we found. There weren't very many, but there were some, which is a natural thing when you're doing something that large scale with biographical information. And then we updated those data through 2021 up to at least this summer. We have a total of 541 state court leaders in the data from 587 selection events. And ideology data for those individuals was updated from the original Paget by actually Teena and David. So David, thank you for contributing there. All right, so first thing we can look at here, and I promise I won't, go overboard with giving you stories and things like I probably could do at this point, having been immersed in this for a while. Look at her, shake her head, yes. But one of the things we were really interested in is the career backgrounds, professional backgrounds of Chief Justices, where they come from, how those backgrounds might affect the way they behave once they're in the office. So broadly, you can see here that the most common trend, of course, was that 94% or so of them came from backgrounds in the courts. But some of them didn't necessarily, or they had other types of backgrounds that we thought were worth exploring. In terms of those that had career experience in Congress, not very many. One currently does, the Florida chief, Charles Kennedy, House member for several years, Republican conservative. 6 individuals served as governor, then later became a chief justice, which again, I think is interesting. We often talk about, for example, Chief Justice Taft coming out of the presidency. Well, there's an analogous event here that's happened several times in the States. Probably the most prominent of those was Chief Justice Richard Hughes of New Jersey, who was a Democrat, but was actually appointed to the Chief Justiceship by his successor in office, Governor Cahill, who was actually a Republican. So a cross-party nomination of your predecessor as governor into the Chief Justice slot, which I think is pretty interesting. If we look at legislators, I was personally a bit surprised to learn that 15% or so of chief justices had previously been state legislators. A prominent example among them, I think, or an interesting one, would be Chief Justice Bevilacqua of Rhode Island, who was House Speaker in Rhode Island and got himself elected as Chief Justice by the state legislature unanimously. Didn't last long in that position because of scandal, faced impeachments, had to resign. Oops. A couple other examples here I thought were pretty interesting from some of these categories. In terms of attorney generals that were appointed or otherwise became chiefs. A current example is Gordon MacDonald of New Hampshire. He was actually appointed initially or nominated initially in 2019, I believe, by Governor Sununu, but was rejected by the state's executive council, which is required to confirm chief justice appointments. But then Sununu left the chief justice position open for over a year until the membership turned over to a majority Republican executive council when he renominated MacDonald and he was confirmed. So he's currently the chief in New Hampshire. Not surprisingly, lots of former prosecutors in the mix. And among that, 5 or 6% of individuals who had no judicial experience and became chiefs, we gave them a lot of attention in the book because we were interested in kind of the relationships that helped them secure a chief justice position despite never having been a judge. Several of them were elected to the position, so they didn't have to rely particularly on some kind of benefactor to appoint them. But a lot of them who were appointed as chief or became chief without judicial experience did so because they were close with the governor. And we provide a lot of evidence for that in the book, which I think is quite interesting. A number of cabinet members, lieutenant governors, people who'd been chairman of the state party, people like that being appointed as chief justice. So again, lots more detail on that in the book or in the chapter, but I'll continue here. All right, so aside from professional backgrounds, something else we gave a lot of attention were the kind of increasing numbers of women and minorities into chief justice positions over time. And this is something that, as I'll show you in a moment, really did develop quite gradually and then kind of hit some spurts when we get closer to the modern day. But the general trend these days, at least taking the long view, is that the percent of chief justices who are women or minorities is getting closer to proportionality with the overall makeup of state Supreme Court seats. So that is something that we did find to be pretty interesting. It does seem like as the pool grows, of course, of minority and female associate justices, we wind up with, of course, more chiefs down the line as they are promoted or run for election or whatever mechanism is used to get them in those leadership positions. All right, so I mentioned that there were pretty clear changes over time. I mean, you can see here that that's not a joke, right? I mean, we go from a place where for both women and minority chiefs, the numbers are incredibly low for a very long time and then start to gradually increase. If we look at female chiefs, there's a few pioneers here that we found pretty noteworthy and to discuss again in the chapter at some length. The first female chief, of course, Lorna Lockwood of Arizona. Many of you probably know that. And then she is followed gradually by a few other women in the years afterward, like Susie Marshall Sharp of North Carolina in 74, Rose Bird in California in 78, who of course is well known for other reasons. And then we start seeing the number of women chiefs really increase once we get into the 1990s. And by 2014, gender parity was actually achieved among chief justices with a 50-50 split, which again, I think is quite interesting and maybe surprising to some people. If we look at minority chiefs, again, we go from a position where there aren't very many at all, and then we start seeing increases. You will notice, however, that, even looking here, in the current day, we're kind of at the highest number, highest proportion of minority chiefs we've had, and that's about 20%. But if we do look at the gradual introduction of minority chief justices, I do want to note that the earliest of them, they do predate the beginning of this graph. The first Hispanic chief that we identified was in New Mexico in 1951. And then New Mexico went on to have a few more Hispanic chiefs early on in that same early time frame, basically from statehood all the way up until the 90s. Every Chief Justice of Hawaii was an Asian American, which is interesting, but it does look like in those states, Hawaii and New Mexico, the fact that there was a large minority population there was associated with, of course, choosing a Chief Justice who was associated with that group as well. Once we get up into the 80s, 90s, we start seeing more chiefs from minority groups. If we look, for example, in 1984 in Pennsylvania, we see the first African-American Chief Justice in the state, Robert Nix. If we think of things like intersectionality and how interesting that is for us, we see the first Hispanic female Chief Justice in Michigan in 1987, Dorothy Comstock Riley. And it's not till 2005 we have the first female African-American chief, Leah Ward Sears, here in Georgia. So, again, I promise not to overwhelm people with this kind of information, but I do think it's interesting, again, to see these proportions change and grow and discuss what that means as we do in the chapter. I'll turn this over to Teena now.
Okay, so a lot of our book and chapter are, as you've been hearing Rich talk about, are a lot of rich descriptive statistics. And Rich is literally a walking encyclopedia right now of Chief Justice information. None of that was written down in notes. Rich just literally spills it as he walks. So therefore, we were interested in terms of thinking about sort of a research element of, okay, if we're noticing these trends, what is it that current research tells us about how folks, women and minorities, are getting picked? Because we do focus a bit in chapter 1 on different selection systems and the different political results that can happen out of it. For some reason, there we go. So the first thing that we wanted to do was think about we categorize, sort of collapse different Chief Justice selection systems into different groupings to see what the differences would be when we compare in the selection events how women and minority candidates were faring. And as you can see, we have aggregate totals for all non-traditional in these, but basically what we're looking at is that, women are faring the best in the election-based system relative to others. And minorities are, well, interestingly, in government appointment or elite appointment systems, as Mike was calling them, women and minorities have about an equal shot relative to men. And overall, when we have government appointment, is where our minority candidates are going to be picked the most. But of course, those are just descriptive statistics in terms of what the overall candidates look like in comparison. So we thought about work that had been done prior to this point, if there was any, in terms of likelihoods of being able to see whether some kind of certain selection system would result in any of these kind of candidates. And there's pretty limited research out there. There's some research that talks about the timing of when will a state, for instance, select a woman Chief Justice, what kind of conditions are right for that. And then we had some specific research that looks at the peer vote systems, and under what circumstances, what kinds of people will they pick, et cetera, et cetera. But we didn't notice in any of the literature that there had been attention paid to all kinds of state Chief Justice selection systems and when candidates such as these would fare the best. So in a model of just a straightforward logit model, so under what circumstances is a Chief Justice selection event likely to result in a certain kind of candidate? We have a model looking at when will a female candidate emerge. We have one for looking at minorities emerging as Chief Justice, and then a combined model for under what circumstances would we have a non-traditional Chief Justice picked in that specific selection system. And as you can see, just from the highlighted components, there's not a strong association for any particular selection system resulting in a certain kind of candidate, with the exception of peer vote systems. You're more likely to get a Chief Justice that's non-traditional, meaning either a woman or a minority, if you have a peer vote system. And we don't think that's startling or a revelation. After all, people are working with their colleagues. They know what their abilities are. They're deciding to vote on people that they think are worthy of the job, regardless of something else. But the one thing that we did notice beyond a control variable here that you'll see, which is just the pool. If the pool is bigger, you're more likely to result in certain kinds of candidates, with the court size variable being significant. But the one trend that we saw overall that was noteworthy is that regardless of whether we see anything with a certain selection system type with a certain kind of Chief Justice emerging, is the liberalism of the state citizenry. And so you can see that significant impact. And here's just the graphed version. So states with the least lowest liberalism or the most conservative, there's roughly a 40 percentage point difference in the likelihood of picking a non-traditional candidate overall. There's no state that is the most conservative, meaning it fits the bill for a 100 on the scale, none that fits 0 on the scale. So you don't see this much difference in actual likelihood, but that's the range of what our findings indicate. And so just in general, what we, with this particular chapter, are looking at is just overall conclusions that in this book, our aim was to understand the Chief Justice and how the Chief Justice fits into the state political environment rather than just inside the court. And we definitely think there's something about the prior experiences of chiefs and the leadership that they're going to exhibit, which is primarily things that they have to exhibit public facing or outward facing and not necessarily court facing. And so there's something to be said about having experience in the political realm and coming in and what you can do on the court and what you do on the court at that point. We also found, not surprisingly, that state Chief Justices have more diversity than their federal counterparts, which of course, with the US Supreme Court, that's a lot of white men, so it's not really hard to increase diversity there. We also found, peer vote systems are more likely to have non-traditional Chief Justices in those roles. However, state liberalism is really the biggest predictor for whether you're going to have a non-traditional leader. And so the things that we're looking at moving forward, which we didn't explore as much here, are the interesting nuances of what kinds of states will pick Chief Justices that have literally no judicial experience, since most 94% of Chief Justices have actually been judges before. So what does it say about a state when they pick someone that has no judicial experience? And the other thing is about looking at these candidates and Chief Justices with these traits of diversity, that some states have never had a woman, 8 of them as Chief Justice, and some states have never had a minority, 29 of them as Chief Justice. And so we're thinking more broadly about what sort of the political significance means, particularly in this day and time of those kinds of places. Thanks, everybody.
Thank you. At this point, I will turn things over to Melinda Gann Hall, who can give our presenters some feedback on their papers.
Thank you. And thanks very much for including me in this panel. It's been a pleasure to read these papers, and it's great to see everybody. So thank you. These papers are all terrific. It's easy to be a discussant when there are major flaws in the papers or theoretical gaps, and there just isn't any of that. So please take my comments as more recommendations for tweaks or to develop nuances rather than any kind of damning criticism, because there certainly isn't any of that merited for any of this work. And in fact, when I read these three papers, I was delighted to see the outstanding state of the field as far as the study of state politics is concerned. All of these papers engage interesting new data and methodologies. We have search engine data, we have Twitter data, we have very detailed, interesting biographical data applied to chief justices, which is certainly an advance. And so that alone is certainly a major positive point. They all do a terrific job of incorporating existing work and existing theoretical approaches. And they all provide interesting avenues for future research, as well as infrastructure for doing it, because a lot of the data in these papers will be wonderful for not only these scholars moving forward, but for others as well. So keeping all of that in mind, let's talk about Todd, Mike, and Mike's paper. I just want to make a couple of comments about each paper so that everyone has a chance to participate. But I thought it was really interesting that judges are using Twitter. And I realize it's not every judge using Twitter, but it's interesting that a significant proportion have done so. So that's interesting. And it does ask the question, it begs the question of who are these people? And I think the one thing I wanted to know in this paper, and that I recommend adding a little bit of, is just who are these people, just a paragraph. And I realize you have an article, and of course, the first thing I did was run to the other article because it's so interesting. Like, who are they? Are they chief justices? Are they, who are these people? And so a little bit more of that, that you don't have to repeat an article, obviously, but just a little bit more information about who the justices are who are engaging in Twitter, I think would be just really interesting. And again, I realize you have another article that does that, but bringing a little bit more of that into this work would be terrific. Explaining who uses Twitter would be an interesting future project. Like, what explains why a justice might be drawn to this particular social media platform, and what are their messages? And along those lines, knowing a little bit about their messages. You have some examples of people who have tweeted, particular types of messages, but what are they saying would be very useful to see as well. When I first read the conclusion, I was a little bit confused, but then I thought about it for a second, and of course it makes perfect sense, because you have this very interesting contrast that elected judges are sort of the center of these networks, right? But these campaign kind of posts and sites aren't. And I thought, well, wait a minute, how can you have elected judges versus campaigns? But when you think about it, it makes perfect sense, because these campaign, accounts might give the appearance, if being followed or liked or in some way commented on, of some sort of impropriety of endorsing a candidate in a race. And so I think lots of judges would be hesitant to do that. So I offer that as another explanation for why these, in addition to what you've already stated, of course, that this might be another explanation for why these specific campaign types of accounts just, aren't central to any of these networks. But again, it's just really interesting to see this work. I highly recommend reading the previous article because this just makes me want to know a lot more. So this is just an incredibly creative idea and, fantastic work. Along the same lines, Marcy, I think your data work is amazing. It's fantastic. It's very systematic. It's an incredibly creative way of using data and making them appropriate for the kind of complex analysis that you're doing in this paper. So brava for, for figuring all of this out. It's a sophisticated, complicated analysis of why the public would be interested. And of course, it builds nicely on David's work and lots of other work dealing with the effects of various types of stories and other kind of media accounts of judicial elections. I think, I want to hear more. I want to see more on some of the variables. For example, Figure 1 graphs average estimated hits per year across time, so from 2004 to 2018. There is a really interesting dip in 2018. So you talk about increasing interest in state Supreme Court elections over time, but when we look at 28, there's a plunge. So what is that? So taking a little bit more time to talk about that particular pattern in the graph, I think would be really illuminating. I also recommend that you think about, especially with campaign contributions, how you might address the issue of district-based elections as opposed to statewide races. Because one could argue, except in the case of huge cities like Chicago, perhaps, that you're necessarily going to have lower levels of campaign contributions in those district-based elections. So you could address that by calculating some kind of general per capita contributions per race, or adding some sort of control for district-based races. But I think that would give you more insight into the effect of campaign contributions on the interests of the public, and actually would give you better results. And the other issue is the issue of partisan elections. I'm going to push back a little bit on the idea that there's no information in partisan elections, because I think there's a lot of information in partisan elections. I think most people vote on the basis of partisanship, and that's the information you're seeking. So we know that's the most important heuristic in the way voters vote in the United States. And you're also interested at the same time in selection systems and how selection systems for the judges would impact public interest. I recommend looking at an interaction effect for partisan elections with just looking at the impact of partisan elections with the types of stories. Because one might hypothesize reasonably that in partisan elections, the number of stories is going to have much less of an impact than it would in something like a nonpartisan election, where there really isn't any information readily available without news stories. And I think that would really enhance your results, because I think, for example, when we look at the effects of campaign ads, we know that attack ads, for example, just don't have any effect in partisan elections. Well, why is that? It's because that's not how people vote, right? But in nonpartisan elections, without that partisan heuristic, it does make a lot of difference. Now we're talking about, support for incumbents and voter turnout with these types of campaign ad studies, but still one might also hypothesize that the type of selection system would also affect the impact of those different types of stories as well, with much less of an effect in a partisan race than any of the others. But otherwise, this is just terrific. And again, just very creative, insightful work. And again, the same is true with Rich and Teena. I was fascinated by the data in this paper, and I really appreciate a deep description, although you do far more in this paper than just describe. And I don't mean just describe as a negative. I think it's actually a huge positive in this case, because we learn a lot about the judges. And there are some surprising trends. For example, it was surprising to me to learn that more of the justices were legislators than they were prosecutors or what was it, or attorneys general combined than state legislators. It was also interesting to know that some had been governors, although I realize that hasn't happened for a while. But these sorts of trends are incredibly interesting. And the data in the paper are described so nicely that I think it's easy for somebody else to pick up this paper, get a really good sense of who's on the court, and go forward. I mean, that's just terrific. But the analysis is also interesting. First of all, looking only at the chiefs is interesting. We just don't have that many studies. I mean, we have Laura Langer and her colleagues' work. I'm not suggesting there isn't any work, but this is an interesting twist on the diversity question that typically looks at everybody on the court. And so we learn a lot, and there are mixed results out there, right? So Mark and Drew tell us that selection system doesn't really matter, but Greg finds that it actually does matter in some contexts, that people who are appointed, you're going to get fewer persons of color in merit and appointment systems than you might in electoral systems. So the literature is not straightforward on this. And so addressing that question is important, and looking specifically at chiefs. I would recommend one additional aspect to the analysis that I think would really connect directly to Laura and her colleagues' article, and that is to think about whether it matters how powerful the Chief Justice is. Because we know in some states, chiefs have the ability to assign opinions, and then in other states, they don't. And you guys know that as well as anybody. I mean, you've published on this topic. So the internal operating procedures of a court might also affect. So are women and other, non-traditional judges more likely to happen when the office isn't that important relative to other judges? Or is it the opposite? I mean, what is that connection? And so I would suggest that is something to think about. But overall, this is terrific work, and congratulations to everybody.
Well, thank you so much, Melinda. We're indebted to you for your thoughts and insight. Before I turn it over to audience Q&A, I might give the authors just a moment to respond to Melinda's feedback. So I will, open it up to the authors now.
Just thank you so much for the comments. Very helpful, and some of what you said is very similar to other feedback we've got. So really kind of thinking about how to integrate some of that stuff into this article without rewriting the other article. And
right.
That's the tricky part, right?
Right. Just a paragraph of, just really condensed, just, give us something, because I kept saying, this is so interesting, I want to know more. So obviously don't repeat the other article, but just give us a paragraph.
Yeah, and that's helpful to think about how to do it. So thank you so much. Yeah.
Oh, thank you.
Yeah, thank you so much. I appreciate all the suggestions, and I think it would help clarify a lot of the results. So yeah, thank you so much.
You're welcome.
And I suppose we'll offer similar comments where we say thank you for the great commentary, comments, and the wonderful suggestion about the inclusion of the CJ's powers in the model. We're still working on maybe a more developed version of that model for a paper that we're doing actually with David. So that's something we'll keep in mind as we put that together.
Yeah, and we were walking a line in this book. I mean, Melinda has one chapter of it, but the bulk of the book is about the leadership that the Chief Justice is exhibiting outside the court. So how much to include of the chief's inner court ability is a line for us of, okay, how much, because we're definitely trying to differentiate. But I really appreciate that. I think that's completely accurate. And also I'm curious, I want to know, just like you. And actually the most helpful thing that you just said for all of us, besides that, is that you said anybody can pick this up and read it. And Rich and I looked at each other and laughed because we've recently had one of our grad students call us accessible political scientist writers. And so that's what we're aiming for, is being accessible political scientists. So thank you, Melinda, for confirming that's our goal here.
Accessible is good.
Yeah, thank you.
All right, well, I guess now we can turn things over to members of the audience for Q&A. So if you have any questions for the authors, we'll now go in that direction. Erico, yeah, go ahead.
Hi, thank you for all the presentation. I really like reading, listening to the presentations. I think I have actually two questions for Marcy, especially, and of course I agree with reviewer, the discussant's points on the how the selection systems really interacting with the these different types of articles effects on the public interest. But I'm also thinking, because I didn't read their paper, so I'm not sure whether you're including the election cycles effects into your model. So to see whether that inside during the election cycle and outside the election cycle, is there any differences between these three types of the articles? And my second point is that I just want to, not necessarily a question, but I think it's worth discussing more about some judicial related articles, because I think of some of the I think some of the people are very interesting in the court decisions on the salient issues on very salient cases like the abortion cases or the same-sex marriage cases. So I'm just thinking, if especially outside the elections, within the election cycle, does these judicial decisions, the judicial related articles have a stronger effects on the public interest compared to the other non-salient issues, judicial related articles? So maybe if you can focus on one specific salient issues or salient case and conduct a study, I mean, that will be helpful to explain that questions a little bit. But I think that's a very interesting project. Thank you.
Yeah, thank you, Erica. I like your second suggestion, looking at cases where there are more salient issues or issues that are likely to have sort of that people pay like national attention to. That would be interesting to look at. I didn't really catch your first question. I think you were kind of breaking it off, but do you mind repeating it? Oh,
yeah, I think I'm talking about the election cycle effects on the different, whether it has whether it's actually amplifying the effects of the, like, for example, campaign related terms, related articles, or the campaign contribution article, sorry, not campaign and contributions articles. Yes, that's right. Yes.
Yeah, so in the appendix, I do a time lag analysis for independent variables. So I mean, the effects don't persist. The effects seem to be pretty immediate. But I think also dividing the election cycle into particular phases might be an interesting way to get at your question as well.
Laura, you want to go ahead?
Sure, thanks. And I want to echo what Melinda said. This was a really cool group of papers. People are doing really interesting work, and it's fun to see all the innovation innovation that folks have on display here. And I wanted to, so my question or comment is for Rich and Teena's project about the Chief Justices. And as I was sort of listening, and this is probably something that's, part of like the bigger book project, but I wondered if you would consider thinking about how the broader racial or gender context of a state would sort of play into this idea about, someone becoming a chief justice. And I say that because I just read Chris Clark's book on Black political representation in state legislatures. And so thinking about the racial threat hypothesis, thinking about how, for a court itself to actually, represent the demographically the population in the state that it comes from. And also kind of the idea, so, like Jason Wendet has some work kind of looking at it like a gender political culture. So, what is the appetite or the willingness or the attitudes about women in leadership, about diverse leadership? And I think, you have like citizen liberalism, and that's part of it, but it might be possible to pull in some of those other kinds of variables that get at what's happening in the state with respect to race and gender in ways that might reveal some interesting things about what you're finding. Of course, there's institutions, the way that people are sort of chosen. I actually didn't think it was intuitive that you would see more women and people of color become chief justices if their peers were choosing them. So I was actually kind of interested to hear you say more about why you think that is, because I could sort of see in terms of in-group, out-group dynamics, maybe it going the other way. So if you have thoughts about that, I would just be interested to kind of to hear those.
Yeah, so I can say that I didn't address it a lot in the presentation, but there's descriptive or qualitative discussion of what you're talking about in the book, but we definitely don't have it in that model yet. And I think that'll be in the more expanded version that we're working on, for the upcoming paper. But you are completely right. When we do see, especially minority chiefs coming into those positions, at least in the early part of the trend line, they are mostly in states where there are large populations of that demographic group in the state. And that was sort of, I referenced the Hawaii and New Mexico early chiefs and how they were very much related, I think, to the populations of those states. There's an old, very ancient, by the way, like Glenn Winter's article in Judicature that talks about the New Mexico selection process and how it's so influenced by the presence of Spanish Americans in the state, right? And that's kind of what that goes into. And of course, with Hawaii. But there's quite a bit of discussion in the book about the rise of African American chiefs, predominantly in the former Confederate states and the border states, right? Large populations, political advantage to come from getting them into positions of power potentially for political elites. And there's a table that shows kind of where all the minority chiefs were appointed, and I have discussion of why, under that. But yeah, it's not in the model. You're right. And we didn't include sort of percent demographic group in the model that we presented, the Logit model. That's certainly something that I appreciate you suggesting, and we'll definitely give that more attention when we continue working in that area.
Yeah, and I think the idea about it not being intuitive that the peer votes result in non-traditional candidates, it's really more of a thought about what the other kinds of selection represent. It's more like the others are so unlikely to, in terms of whether it's seniority or so when you're looking at, which ones can you tick off, are women more or non-traditional candidates more likely to rise to the top? The others are more of a stacked against than pure vote. Pure vote seems to be more of an equalizer.
Well, and some pure vote systems, not all, we can't make this assumption. You've seen this in the literature by, Langer et al. And others. Some of those pure vote systems use seniority as a de facto kind of selection mechanism, right? So the more time there have been minority or female chiefs there, the more likely they would rise to the chief position.
Exactly.
That's not true in every state that has pure vote very clearly. Sometimes even where they do that traditionally, they just choose to violate it for whatever reason they can post hoc justify. And the media, the news articles about that are always fascinating. And there's some court administrator saying, yeah, we've had this tradition for 188 years, but not this time. What? Why? We did talk about it also in terms of them being able to make better judgments about who would be a good leader from within the court in a pure vote system, or who's qualified. I would argue that we could see that at least in some cases, but we do know if we look at the qualitative evidence, at least up to like the 1980s, there definitely were male members of courts who said openly to reporters, I won't have a woman lead this court. That stuff was happening. So that's something we discuss as well.
Yeah, and I guess to tack on to Laura's point, y'all might want to consider looking at an interaction effect between state liberalism and demographics, because you got southern states in particular where in Alabama we elected 3 African American jurists to the Supreme Court, never the Chief Justice, but that was only possible in the 80s and 90s until voters switched and became Republicans, and ever since then the court has been all white. So maybe something to consider as well. Michael?
Yes, thank Buddy for such great research that you've shared. I had a question for Mike, and Todd. Do you look at the actual content of the tweets and what the justices are actually saying? I know that our discussant had raised this, but in looking at your theory, you have these 3 goals that you believe judges are pursuing when they are engaging in Twitter: collegiality, professional recognition, and progressive ambition. And I just wonder if each of those goals would be served by different types of tweet and content of those tweets.
So thank you for the question. Taught in my 2019 article in the Journal of Information Technology and Politics, digs into the content of the tweets. We do a structural topic analysis to look at what's going on, what the kind of trends are, what sort of differences there are in the content of tweets between elected judges and judges in non-elected or competitive elections versus non-competitive election system. So we do a lot of stuff with the content of tweets in the first paper. One thing that we're going to have to go back to though in the future is because we've introduced these sort of new ideas of interconnectedness and building a judicial network, is in the future we need to go back and not only update the data, but also look at how these new expansions to our overall theoretical arguments, then how that impacts the content of the tweet. So definitely we've done some work with content, and if you find it interesting, please check out the 2019 piece from Todd and me. But yeah, it's also something that we want to do more with.
Thanks. Mark, would you like to go next?
Sure, although I think Shane's hand was up before mine, so you want me to defer?
Shane can wait. He's used to it.
All right, there it is.
But yeah, go ahead, Mark. It's no big deal.
David has spoken, so we'll go by that. So I have one comment for the Todd, Mike, and Mike paper, and then a question for Teena and Rich on their paper. So I just want to give a little context here, and I think that Larry Baum was here, but he no longer is. I just want to give a little bit of, how this research that you guys are doing has I really like what you've done with it and how it's evolved over time. A little bit of inside baseball here. I was actually on the Pritchett committee that decided that Larry's Judicial Audiences book should be the winner that year, and I think it was 2006 or 7 or whatever it was, or something like that. And then the next year, when I was teaching the, I happened to be teaching the grad seminar in judicial behavior, And Mike and Todd were in that class, and so of course I assigned that book because I love that book. I mean, I hope, you know, I voted for it, obviously, for the Pritchard Award. And it was funny, what Todd and Mike said in the intro to their book was that, you know, and Mark had a throwaway line. What about state courts? Would this apply to state courts? For the record, that was not a throwaway line. I had thought about it. It was in my notes, because I said, if any place where this should work, it should be state courts, right? You know, particularly when you have, you know, contested elections and things like that. Of course, Twitter didn't exist then at that point. And the fact that you guys are now using this and applying it to what Larry originally did, I just think is just so cool. So kudos. And it's nice to see, you know, what my former students who are scholars in their own right and taking things off. It's just really rewarding to see. So nicely done. So that's my comment on that. My question for Teena and Rich, since as Melinda said, yes, you know, Drew and I have been involved in this area. We didn't focus specifically on the Chief Justices, but you know, when we started this research like 20 years ago, as you guys said, there's not much research on it. There wasn't much then, particularly when you're looking at the causal influences on diversity. There wasn't much then. There still isn't. And I still can't believe there's not that much. So one of the things that we found, as Melinda said, was that there just isn't, that selection system doesn't matter all that much. But that's a function of time. Okay, as we got into the latter, you know, the latter time periods, that's where we found that it didn't matter so much. But it did matter earlier on, and it was different for women and for minorities as well too. So I'm wondering if you guys were able to disaggregate any of that, or if you have looked at any of that. Do you think it might be worth looking at it? Because I know you said that, I think you said women fare better in elections, minorities in appointments. That's aggregated across your entire data set, I believe. So I'm wondering if you disaggregated that, what you think you might find on something like that, because we didn't look at the Chiefs, and I'd be curious. And as we all know, endpoints, you know, the way you set up data, there's reasons that Greg came out different than we did and things like that. And it's the way it should be. That's how we learn. That's how science advances. So that's my question.
Yeah, we were sitting here thinking whether we did some disaggregation in another chapter where we looked at the range of ideology for Chief Justices, but in this particular context, Rich and I were recalling, I don't think we disaggregated, but Rich had a fair point, which is that we didn't have a sample size of enough until basically, you know.
Not till the 90s.
Yeah.
Was there even an influx worth, you know, that could generate meaningful analyses?
Yeah. Also, your work is cited as some of the very minimal work that's out there. So you get a shout out.
Well, thank you. That wasn't the reason I was saying this, but you're right. I mean, they're just, well, one of the reasons we were able to do what we did over time was because we looked at everyone, not just chiefs. So we had a strong enough end where we could do that. But no, this is terrific work. So I'm looking forward to seeing more.
All right, Shane, you're up.
All right, thanks, David. I have a question for the Todd, Mike, and Mike paper. You know, the thing I am really curious about is, you know, not just the presence on Twitter, but also the frequency at which they're posting, because I'm thinking, let's say someone is a judge that posts, you know, but, you know, once or twice a month, as opposed to someone who's, you know, like extremely prolific on Twitter. And that's going to have a different effect. And it might even allow you to kind of move into the world of looking at strong ties and weak ties. And, you know, that might also be a mechanism, I would, you know, say to maybe, and you know, you present an exponential random graph model, but it might be worthwhile to, in that instance, look at it as like a generalized exponential random graph model to account for tie strength. So I'd love to hear your thoughts on that.
Mike, are you here?
Yes, don't worry.
Don't
worry, I am here. Yeah, so that is something that like I have a few notes actually like scattered around my desk of things that we have to eventually do with the project. And one of them is get better and figure out a way to deal with like super users on Twitter, because like there are some big outliers in the judicial network in terms of number of tweets and like just frequency of use. I'm thinking of Chief Justice McCormick, for example, and Judge Dillard especially. There in the original version of this presentation that we did like long time ago when we were doing first cuts of the data, I did a full map of Chief Justice McCormick's Twitter network, and it is gargantuan to say the least. So like being able to control for that when you're looking at like how frequently are they actually sending out things is one thing that we're kind of looking to kind of suss out and figure out basically. But yeah, pulling in the question of like how strong are the ties essentially is kind of the next step here. We do a little bit of that, or kind of try to get to that just a little bit by looking at follower count versus like how much they're following essentially. But obviously the frequency of use is going to be a better mechanism for that in the end, but it's just working out how to like deal with the anomalies there is really what we've got to play with, because simply logging it, even doing that, you still have some that are like way outside of the bound. So
awesome, thank you very much.
Yep.
Thank you, Mike. And I think for our last question, we'll turn it over to Marcy Shieh.
Yeah, thank you. I just had a quick question for Todd, Mike, and Mike's paper. I was wondering if there is any intention to sort of expand on this project a bit more to look at how people react to justices who have Twitter accounts. Like it just seems that it seems like a Supreme Court justice would probably never open a Twitter account. So does this influence people's public perception, thinking that the court is less legitimate or more legitimate? I mean, I would be curious as to what your thoughts on that are.
We actually proposed something similar, something along those lines, as a sort of survey experiment, and we it was an idea that we were going to start working on, and then we got sidetracked with some other stuff and have never come back to it. But it's on the agenda. It is definitely on the agenda. It does make sense, because the interesting thing, and Todd and I talk about this a bit in the first paper, is that state high court judges, at least, use Twitter very responsibly, sometimes amusingly. But what they don't do is just the crazy stuff that you see from other politicians. So it may be that it doesn't impact their legitimacy or their public support at all. But it was something that that's on the future agenda.
I'll say those other things that got in the way were like 2 kids in a pandemic also. That's why we haven't gotten to it. So it definitely was something we really wanted to do, but Todd had kids, so.
And there was a pandemic, and I became a DGS, and
yeah. Todd's not here, so I can call him out and say that it was his fault. So that's what.
Well, personally, I would love to see a survey experiment on something like that, just to, go back to that old saw from the legitimacy literature that to know courts is to love them. We could really put that to the test.
Yeah, like the interesting thing with it, and kind of getting to what Mike's point was, is, we wonder about the legitimacy of the court and whether or not Twitter will like delegitimize them or versus give them more legitimacy. But like, given the way that they actually do use it, like to construct a tweet that might delegitimize the court would go way outside of like what they actually use Twitter for in the first place. So like, we really have to some degree, just watching them kind of play out in the wild essentially really gives us a clear idea even before we conduct the survey experiment. But it is something that we still want to play with.
Well, not to mention, a lot of these state judges are accountable to these ethics commissions that legislators are not accountable to. So like in Alabama right now, we've got a judge who's on trial to be stripped of her position simply for saying words in court critical of the death penalty.
Yeah, I was about to say the same thing, David. That's that, and then also what the state bar, the rules are about media use as well. Might be something you want to look at.
Well,
Yeah, 'cause
there have been a number of state judges, trial judges, reprimanded for their social media use.
Yes.
And this is actually quite common, or maybe not common, but at least it's not rare. But to my knowledge, there is 0 instances of this with state high court judges or even with state intermediate appellate court judges.
Yeah, something to consider. Yeah, because those canons of judicial ethics are so vague, you can run afoul of them for saying, virtually anything. Well, if there are no other questions, I think we might bring the gavel down on this session. I want to reiterate my thanks to all of our paper authors for having presented excellent research today. I want to reiterate my thanks to Melinda Gann Hall. We were really quite lucky to have her serving as our discussant on this paper. And I want to thank Bob Lincoln, who sings along every time I unmute my microphone. And thank you to everybody from home who took the time to attend today or ask questions. Please be on the lookout for the next brown bag, which should be announced in the coming days. We're looking to get one more in December before the end of the year. So I hope you'll be able to join us then. And we'll see you all next time. I hope you have a really nice Thanksgiving. And if you're traveling, please be safe.
Thank you, David.
Thank you.
Thanks,
Bye.
David.
Thanks, Shane. Thanks for getting us together.
Bye.